Hi, this is Kevin Davis of KD Training and Consulting. And in this day and age of uncertainty in law enforcement, health and welfare, especially in light of the fact that my brothers and sisters in blue are working in some arduous conditions out there, uh, I've been asked to provide some online training, and so that's why I'm here tonight to do that. So that said, I'm going to share my screen here, and what we're going to be talking about today is my forte, which is use of force training. All right, what we have up now is the first slide. So this was a presentation that I had done for ILEDA in 2019 at the conference. And if you're a law enforcement officer, especially if you're a law enforcement trainer and are not a member of ILEDA, I strongly suggest that you join. It's an excellent organization, and the conference there's nothing like it in the United States in terms of law enforcement training. So what we're going to do is we're going to look at this program and these slides. And of course, this one may be familiar to many of you. This is, of course, outside on the steps of the Lincoln Memorial a couple of years ago when Covington Catholic were confronted by some protesters with agenda. And this is what I like to say is the smirk heard around the world. If you can look here, it appears as if this young man was smirking at this Native American gentleman who confronted him on the steps while this young man was waiting for a bus to take him and his classmates back to Kentucky. And as you may remember, this picture went viral and was picked up by a lot of news programs, a lot of cable news outlets. They really beat this kid up, and I like to call this the bias of incomplete information. In other words, people were making judgment or passing judgment on this young man before they even knew what the full story was. And another way to say that is that it was a rush to judgment. Of course, in reality, when more video became available on this particular incident, we find out that this young man was just being polite. He was just standing there when this gentleman walked up and confronted him, and he was just standing there and not responding. And as we now know, he's won settlement from at least one cable news organization because of this. Let's take a look at that same rush to judgment when it involves law enforcement, especially law enforcement use of force or use of deadly force. In this case, we're going to talk about the Stephon Clark shooting in Sacramento. And, this shooting took place a couple of years ago. If you don't remember it, Stephon Clark was running around the area performing damage to vehicles and breaking into vehicles when he was confronted in the rear of a home. The home happened to be owned by his grandparents, but the police didn't know that. When they confronted Stephon, he advanced towards them with his cell phone held in a two-hand grip, and he was shot and killed. We know from this incident that the police chief and the police community came out and passed judgment or were seriously looking at this in terms of a use of deadly force investigation. We also know that the district attorney looked at this as well. And a friend of ours, Dave Blake, was hired as an expert to look at the Stephon Clark shooting and make an opinion or render an opinion. He did so, and it's available online. I highly recommend you read it. And the district attorney, Ms. Schubert, came out and found that the officer's use of deadly force was within the law. But that doesn't stop things nowadays, and that's the problem with police use of force. Everybody looks at these things through the prism of their own reality or with their own agendas. And from that, we see the mayor from Sacramento came out and made this statement. And he said, I believe that the standard, and that's the Graham v. Connor standard of objective reasonableness, that needs to be changed. I think the question must be, was the shooting preventable? The current constitutional standard that dates back to, I believe, the 1800s says that if an officer-involved shooting is deemed reasonable after the fact, that it is then justifiable. The problem with that is it's not the 1800s. Now, the California statute went back a number of years, but in the Stephon Clark shooting, they used Graham v. Connor and the objective reasonableness standard, and that standard is from the 1980s, not the 1800s. But you can see how different groups, once again, look at these things through their own prism of reality. And that can happen with politicians. I know you'll be surprised at this. This is Shirley Weber. She's a assemblywoman in California, and she was instrumental in passing a new, more restrictive language in California use of force, specifically use of deadly force law. The problem is that when you look at the quotes of Shirley Weber, you find that she's not relied on the truth of the facts, and she never let those get in the way, apparently, from her pursuing her agenda. So now California has a more restrictive use of deadly force law in the state. What we're really talking about today, and this applies to the Stephon Clark shooting in Sacramento and so many other shootings, is totality of the circumstances, or what I like to call context. And too many times law enforcement agencies don't put out context or the totality of the circumstances after an officer-involved shooting. And that can be really to their detriment. So we're going to examine what totality of the circumstances or context looks like in the law enforcement application of force. First of all, oftentimes we get off on tangents and we apply policy. The court said in Smith versus Freeland that the issue is whether the officer violated the Constitution, not whether he or she should be disciplined by the local police force. See, that's the problem. We juxtapose or we commingle the use of force investigation, the legal aspects of the use of force investigation, with the internal policy questions, and that's not what we're supposed to be doing. The question is not whether the officer could be disciplined. And another thing that we oftentimes do is what I call a tactical critique, and this term was coined by California law enforcement use of force trainer by the name of Jeff Cope. And this focuses on tactics that the officer used prior to the use of deadly force. And once again, that's not the question. The question is the actual seizure or the hands-on part, and whether at the moment force was used, whether it was objectively reasonable based on the totality of the circumstances and the officer's reasonable perceptions. It's important to remember. If you want to learn more about this stuff, you can read this excellent piece published last year by Christopher Logel in the Berkeley Journal of African American Law and Policy. It's called Cracking Graham. From that piece, and which is an excellent resource for you, we read that while it is inherently reasonable for different departments to have different use of force policies, the meaning of objective reasonability and by extension of the Fourth Amendment is not so variable. And that's the problem. It's that, use of force policies vary throughout the country. You have policies that focus on things like intent, ability, opportunity, jeopardy, and preclusion. Those things are not part of the Graham v. Connor constitutional standard as defined by the Supreme Court of the United States. So let's not get off on the weeds or get off on an agency policy. What we're trying to find is whether the officer's use of deadly force was within the law. Let's talk about that law. I testified as an expert in this case out of Pennsylvania. The state's expert said this about my officer, who is an off-duty part-time school resource officer who was involved in a deadly force situation. The state's expert said the requirement for all law enforcement professionals based on the totality of the circumstances in the moment of any particular law enforcement related encounter is reasonable decision making. And I pose this question, and I lead in and I'll ask you, is that what it is, reasonable decision making? And I would say no, because an officer can have a bad decision made but a perfectly good use of force, and also he can make a decision and not affect the seizure. So the question is the seizure or the use of force objectively reasonable, not as decision making? And he goes on, when we take that thing and look at reasonable decision making up above, what I did is put Graham v. Connor into Word document, did a search for reasonable decision making. And this is the only thing that I could find in Graham. The fact that police officers are often forced to make split-second decisions about the amount of force necessary in a particular situation. That's the only place you'll find decisions or decision making in the Graham v. Connor standards. It's not about a mental process like decision making. It's about the seizure that the officer makes. This same expert went on to say there is a necessity requirement, including legal constraints and warnings, if feasible, such as stop or else shoot. Now, this is part of Tennessee versus Garner, but not Graham v. Connor. And in the Tennessee versus Garner decision, the Supreme Court said that the officer must give some type of warning if feasible, if able, in other words. It's not required by law, and oftentimes it in the moment is not possible. So we're not talking about necessity here, and that, my friends, are when people get off on really far into the weeds, and that's what this graph is about. For instance, from the Jason Van Dyke trial in Chicago, where Officer Van Dyke used deadly force on a PCP-affected minor by the name of Laquan McDonald. This was the defense attorney's legal instructor in the basic academy for Jason Van Dyke. And listen to what she has to say about her legal teachings reference the use of force.
Teach the recruits that in very limited circumstances they can use deadly force, correct?
Correct, assuming it's reasonable and necessary.
Correct. And in any instance when they're using deadly force, you hammer into them that it has to be both reasonable and necessary, correct?
Reasonable and necessary to prevent death or great bodily harm for justification number one. For the other three, it's reasonable and necessary to prevent the defeat of the arrest.
But each of them, it either has to be reasonable and necessary to prevent death or great bodily harm, or reasonable and necessary to prevent an arrest.
The defeat of an arrest, right. Yes.
Thank you. But no matter what the circumstances are, there is that qualifier that it has to be both reasonable and necessary.
Absolutely.
Okay. And you hammer that into them, correct? Mm-hmm. Would it surprise you that if I told you that reasonable and necessary or some form of those words appears over 15 times in the 3 pages in the worksheets that you just reviewed as defendants 15 and 16?
That would not surprise me, sir.
It's bolded in places.
It is.
It's underlined in places. Mm-hmm. It is made very clear to them that it needs to be reasonable and necessary.
Yes.
And you spoke about Tennessee versus Garner.
Mm-hmm.
Part of what Tennessee versus Garner stands for is you can't just kill someone to arrest them, right?
Of course.
And it talks about, and this is in your materials, where feasible, some warning should be given, correct?
Yes, where feasible. Mm-hmm.
And so something like stop or I'll shoot.
Yes, there are times, however, we teach them that they won't have time to make such a warning. So Tennessee versus Garner requires the warning if feasible.
Right, yes. So if they have time, they should say it.
Yes.
Now, the reality is when you look at state law in Illinois, where the shooting took place in the city of Chicago, as well as throughout the country, reasonable necessary is not a part of Tennessee versus Garner or Graham v. Connor. And even law professors can get that wrong. In this tweet, you see a law professor, and I've intentionally blackened this out or blurred it, where he says 26 states use reasonably necessary or perceived as necessary, 7 states use necessary, 5 states use officer believes, and 2 states use officer reasonably believes. And yet, when I took all 50 states' use of force laws and I put them into a word search engine, here's what I found, that reasonable and necessary appears only once, and that's the state of Idaho. However, it goes on to say a peace officer is justified in using that degree of physical force, which he reasonably believes to be necessary. So on one line it says reasonable and necessary, but then it kind of contradicts this later on. No state in this country use reasonable and necessary as their standard. All right. But what happens when we get off in the weeds and politics interject into police use and force? Let's listen to a little segment of from NPR about this.
Many of them can even quote from the Supreme Court ruling that it's based on, 1989's Graham v. Connor. But they may be assuming that it shields them more than it really does. David Harris is a law professor at the University of Pittsburgh, where he studied police use of force questions for years.
It is highly protective of police officers, and that is one of the reasons that they like it. But the rights truly belong to the citizen.
Harris says the standard is actually a floor for the rules that govern the use of force, and it's a floor that the states could raise.
If the legislature in California decides it is going to give its citizens greater protection in the sense that it is going to order its police officers to effectively wait and hesitate to use force in a greater number of cases than, say, Graham versus Connor would require, that is their option to do that.
And this is where we have right now, this is what we have throughout this country. In California, activists were successful in lobbying for change, despite the facts of Stephon Clark and so many other use of deadly force situations in that state. In other words, they drove their agenda through. Now, some would argue that the current language or the new language mirrors Graham. Others would say we don't know yet because the courts have not really dealt with this extensively since the law was changed. But we will find out. So let me ask you, this is a hypothetical situation that I'm going to confront you with right now. Outside, and we're talking about lesser force options, outside, which of you would want to walk out on a call right now and deal with a subject with a knife within 15 feet? Do I have any? I'll tell you what, I'll do 21 feet. Let's start with 21 feet. How many of you would want to go outside and confront a man with a knife 21 feet away from you? All right, now let's go to 15 feet, now even closer. So no takers there either. Well, imagine that this person with a knife is under the influence of PCP, is kind of running amok in a industrialized area, and has already threatened a truck driver in the area with a knife. How many of you would want to take me up on that or handle that call? Well, that's exactly what Jason Van Dyke dealt with in the Laquan McDonald shooting. So when we talk about these things, we need to examine the facts of the matter. All right. A hot button topic right now is de-escalation. In reality, I would suggest that oftentimes the suspect is the driver of de-escalation. Now, we always recommend safe tactics, safe deployment strategies, waiting for backup, slowing things down if time is possible. But in reality, the suspect is the one who dictates de-escalation or is receptive to de-escalation techniques. In this day and age, we have to be mindful that this is a hot button topic, but understanding that de-escalation is really suspect driven. All right. Now, let's take a look at totality of the circumstances, how fast things can happen. This is a shooting that took place in Napa Valley. The police officer here is at the driver's side confronting the suspect who is behind the wheel. And we'll see how fast things can move. Now here we have it slowed down to, I think it did about 10% or less than 10%. And see if you can pick up how quickly this moves. At the bottom of the frame there, that counter is frames per second at 30 frames per second for this video. So this shooting actually took place in less than about a half a second. So we really have to be mindful of that, all right? When we're dealing with subjects with guns, a subject with a gun can always lift and fire before an officer can react and respond. That's the totality of the circumstance. Remember, we're talking about response time. Oftentimes we're told action beats reaction. Well, action beats response time because reaction time is strictly a mental process. So you couple reaction time, the mental process, with movement time, and you get response time. And that's what we're talking about when we talk about human factors. And here's just a list of some of the things we look at: the number of suspects, the size, condition, and age of the suspect, availability of other weapons, reaction time or response time, and time pressures like we talked about, duration of the action, violent history. If you've dealt with this person before and they found them, they've resisted before or assaulted a police officer, that can be factored in. Bystanders that can injure you or that can present a threat to you. Environmental conditions such as fighting in the mud, snow, ice, whatever it is, even the ambient light conditions, injury and exhaustion. Resistings or use of force incidents that take place and last more than about 15 seconds, officers really bottom out on energy, and there's a reason for that. A fight that goes 2 minutes is a hell of a fight. Exigent circumstances, things that we don't know or in special knowledge about the person or perpetrator. All right. So some of this can be factored in with perceptions and misperceptions. And a couple of friends of mine, Daryl Ross and Randall Murphy, did some research using some high-tech simulators, FAT simulators, and published this. And they said this, and I'll read this for you, is that the investigator must be knowledgeable about the science of human performance under stress. Understanding how stress impacts human performance will assist the investigator in obtaining the most accurate assessment of the incident. It will later assist when the investigator conducts an interview with the involved officer, and will assist in obtaining the most complete and accurate analysis, which can be cross-checked against other evidence collected. So this is important that investigators and supervisors understand human factors involved in use of force investigations. That's totality of the circumstances. And a couple of friends of mine, Joe Ross and Bruce Siddle, said in 2003, they found that about 1/3 of the officers experienced memory loss after the event. For a majority of the officers reporting memory loss, it took 2 sleep cycles to recall the event. More commonly, memory was restored between a few hours and 1 sleep cycle. About 42% of the officers reported a triggering event assisted in the memory of the event, the most significant being a visual. And of course, when we apply totality of the circumstances and research, such as this done by Tom Hantz, 2 friends of mine, Ray Reagans and the late Tom Hantz, we find how fast subjects can cross certain distances. We've heard about the Tuller drill about 21 feet, about a second and a half. But when Tom Hantz and Ray Reagans did some high-speed videography on people that were running, they found that it's actually closer to 20 or 30 feet in about 2 seconds. So depending on the level of holster that a subject has, if you have a guy with a knife that's running at an officer, it's actually closer to 30 feet. Imagine, once again, when we're talking about action and response time, when we take a look at this shooting, which took place in the South a couple of years ago. And we'll play it again because it happened so fast. The officer is asking for the subject to see his hands. The officer is thinking taser or resisting, when in reality, what the subject has is a gun in his hand, and he's just buying time. And as soon as he moves, he shoots. And the officer triggers the taser. We can actually see the taser door from the cartridge in the air. So he fires the taser, but the subject fires and wounds the officer. Fortunately, he survived. So when we talk about use of force, totality of the circumstances, we need to dive a little bit deeper into the event. We need to find out more. We can't rely solely on video. That's a flaw that I'll deal with in the next training program. But until then, I want you to be safe out there. Remember that training is the key, folks. And if you ever need anything, my email is trainerkevindavis@gmail.com. There's my website, KD/or-forcetraining.com. And of course, if you want to learn more about use of force training or the use of firearms, I have a couple books out there, Use of Force Investigations and Citizen's Guide to Armed Defense. I thank you for your time. God bless you and keep you safe.